Hey, it's Nate Charles back with another episode of the Rule of Law Brief. A while back, I said something that a few people doubted. I said no member of Antifa will ever be indicted because of their membership in Antifa. And here we are. The U.S. Department of Justice is now touting a new indictment from the Northern District of Texas as supposed proof that people like me were wrong, that an Antifa cell has finally been charged as terrorists, except that they haven't. And this indictment, the United States versus Cameron Arnold and Zachary Evitz, proves my point better than anything else could. So let's start with the facts. The Justice Department, under the deeply partisan leadership of Attorney General Pam Bondi and Kash Patel, the current FBI director, have called this an indictment of a North Texas Antifa cell. But the law doesn't really work that way. There is no such thing as a domestic terrorist organization designation in the United States, despite Donald Trump saying otherwise. The State Department can only designate foreign terrorist organizations: ISIS, Al-Qaeda, Hezbollah, the FARC, under Section 219 of the Immigration and Nationality Act. So this fictional political designation of Antifa has absolutely no legal effect on any criminal prosecution. None. It's just political rhetoric. Now, what does the indictment actually say? According to the document filed in the Northern District of Texas, the defendants allegedly attacked the DHS's Prairie Land Detention Center in Alvarado, Texas, on the night of July 4th, 2025. The indictment repeatedly calls the group an Antifa cell, but that label doesn't appear anywhere in the criminal counts themselves, and for good reason. Here's what they're actually charged with. Count 1, providing material support to terrorism under 18 U.S.C. Section 2339 and that A matters. Counts 2 through 4, attempted murder of federal officials and employees under 18 U.S.C. Section 1114, and counts 5 through 7, discharging a firearm during a crime of violence under 18 U.S.C. Section 924C. Notice what's missing? Section 18 U.S.C. 2339B. That's the one that covers material support to a designated terrorist organization, specifically a designated foreign terrorist organization. Antifa isn't one. Never has been, never will be. So what is Section 2339A? It's a different statute entirely. It's kind of a catch-all provision that makes it a crime to provide material support or resources to anyone you know is about to commit a terrorist act. It applies to specific conduct, not membership in any particular group. And that's why it's rarely used. Because prosecutors like me, when I was at the National Security Division, have to prove that the defendants knew the support they were providing would be used for one of a list of statutorily defined terrorism offenses. Bombings, assassinations, or attacks on government officials, just as an example. That's a really high bar, and it's got nothing to do with the designation of a terrorist organization. So yes, if the government can prove the allegations in this indictment that these individuals planned an armed attack, they might be convicted of material support to terrorism. But that conviction won't make Antifa a terrorist organization. It would just mean that these people committed a terrorism offense. And that's the whole point. DOJ and FBI know exactly what they're doing when they call this an Antifa terrorism case. They want to make it look like the federal government has finally taken down an Antifa cell, when in reality what they've done is prosecute alleged violent acts that stand entirely apart from any political movement. The Antifa label is window dressing. It's just a talking point. It's meant to give their press release some punch. But from a legal standpoint, this is just a violent crime indictment dressed up as a national security headline. So yeah, I stand by what I said. No one will ever be indicted because they're a member of Antifa. And this case proves it. Because when DOJ finally had its chance, when they supposedly had an Antifa cell dead to rights, they still had to fall back on 18 U.S.C. Section 2339A, not the far more popular Section 2339B, because the designation doesn't exist, because domestic terrorist organization is not a legal category, because the law still draws a bright line between ideology and conduct. I'm Nathan Charles. This is the Rule of Law Brief. Let's keep reminding them the words terrorism and politics are not interchangeable.